So good morning. We're here in Providence, Rhode Island, at the Supreme Court building. 2 more stops, and then we're done. It's 32 states. So we're about to provide service on the Supreme Court of the state of Rhode Island for the crimes of deprivation rights under colored law, conspiracy to private rights, kidnapping, and other crimes is ascertainable by the evidence on the record. So the United States Constitution provides the baseline requirements that every single state must follow. It's the only thing that makes America America, is American laws. So these American laws that are put into place, that's what connects Rhode Island to Massachusetts or Rhode Island to California. This is what makes America America, are the American laws. You know, and I was out to breakfast this morning with a politician, a congressman, and we were talking about, you know, the future of America and the fact that if we don't address this issue that I'm trying to get addressed here, we will no longer have a country. We'll no longer have a nation. We'll have 50 autonomous nations, each with their own ability to create their own laws, treat people however they want. We will no longer have in America if we do not stand up and fight for American laws. So we don't need to fight for Rhode Island or fight for Connecticut or fight for Texas. We need to fight for America, right? And the only thing that makes America America is American laws. So when a state chooses to enact its own alternative legislation and then substitute it for the provisions that guarantees the Constitution, that would be unconstitutional. It would be an act of sedition, because sedition is defined as speaking or writing the words, such as law established, in order to cause disaffection of the Constitution to procure its alteration in other than lawful manner. There's one way to change the Constitution, and that can be found in the special amending procedure of Article 5, and it has nothing to do with a state creating its own laws and imposing its will upon the rest of the nation. Thomas Jefferson said that federalism is not a single state or small factions of states imposing their will upon the rest of the nation, but instead acting in the aggregate and an essential buffer between the central government and the people. You see, the states ceded their sovereignty the moment that they subjected themselves willingly to the supremacy of the United States Constitution, right? A sovereign state is defined as a state that's complete in itself, not subject to higher government's laws. These states are not sovereign. They do not have the authority to act autonomously because they subjected themselves to the supremacy of the United States Constitution. A non-sovereign state is defined as a state that is not complete in itself, subject to higher government's laws. A sovereign state is state complete in itself. States are not complete. They are subject to the supremacy of the United States Constitution. They did that upon entry into the Union, and so as a result, they do not have the authority to create their own laws, substitute them for the provisions and guarantees of the Constitution, because that would be an act of sedition. It would be altering the Constitution in a manner other than what is prescribed in the requirements, in the law. So when the state does this, right, when the state does enact its own laws and then subjects the people to it through one of its agents, that would be a crime. Agents do not have the authority to rely upon an inferior state statute that directs them to do something contrary to the provisions and guarantees and obligations that they have defined within the Constitution of the United States. Because when they take an oath, that oath is written to the Constitution of the United States. Those requirements, the performance requirements, are defined within the Constitution. So therefore, when they fail to fulfill the obligations that they have, well, that is a crime. Title 18, subsection 242, deprivation of rights under color of law. Now, Title 242 says, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution, commits that crime. So when a prosecutor who has the obligation by oath to follow what is required and mandated by the Constitution of the United States, when they fail to fulfill those promises, those obligations, they have committed that crime. Now, this is a per se crime, meaning that we don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge derives from the promise they make. If you take an oath, you must fulfill that oath. You have an obligation to do so. You promise to do something. You promise a future outcome, and you're not fulfilling it. So, you know, our system of government relies upon our ability to have faith and trust in each other. I must have faith in you to do the right thing. You must have faith in me to do the right thing. We must have faith in the judge to do the right thing. And then we all must have faith in the system to make the right decision. Because our system is built upon faith. Faith is the core of our system. So if I cannot trust you, if I can't believe in you to do the right thing in a very difficult situation, then we don't have a system that functions in the manner in which it's supposed to. So we all need to step back and take a look at ourselves and say, you know, am I a man of my word, or am I a woman of my word? Do I have integrity? Am I going to do the things that I say that I'm going to do? Because all of you public officials, you need to understand that you made a promise to the people of the United States, and you're not living up to that promise. And those are not people of integrity. If we're going to be led, we're going to have leaders, then those leaders need to lead us in a good direction. And men and women that don't have integrity because they can't be trusted to do what they say that they'll do. They can't be trusted to make the right decision in difficult situations. Those aren't leaders, right? Leaders are ones that accept the obligation that they have, they accept the greater will of the people, and do what's right for the people. So right now, today, we're going to go in here. We're going to provide this notice to the Supreme Court of the state of Rhode Island. We're going to ask them to step up, discharge the duties of their office, fulfill the obligations that they made, the promise that they made to the people of Rhode Island, and enforce the laws of the United States, as agreed upon, as written, and as they promised. Because if we don't, then I'm afraid that we are not going to have a nation much longer. And I don't want to see that. So a patriot is defined as one who loves and defends his country. And I'm proud to say that I'm as much a patriot as this country's ever produced, because I love this country. But if you say that you love something, but then in the same breath can't say that you love your fellow countrymen, remember, this country is simply an aggregate of the people. So how you treat your people is a direct reflection on how much you love your country. And today, I can honestly say that you guys don't love this country very much. And so you need to take a look at yourselves and you need to decide, is that how you want to be remembered? And if it's not, then I would really suggest to you guys stepping up, living up to the promise that you make, be men and women of your words, do the things that you say that you'll do, because that's what the people need. They need that right now today. They need men and women of integrity that are leading us. So God bless you guys. We'll talk to you here in a bit, and look forward to getting this done. Hopefully getting on with my life. So thank you. Here we go. How are you? Good, good. So my name is Tanawah Downing, and I have ongoing federal litigation with the United States Supreme Court. The state of Rhode Island is not currently joined in our litigation, but there's elements that they need to be made aware of. And so what we have here is we have a notice that needs to be provided to the justices here. Top is the certificate of service. Inside is my contact information. We have the written affidavit from the affected party here. Our hope is that the justices will recognize this and direct the judicial officers within the state of Rhode Island to act in a lawful and constitutional manner, so we can avoid any further litigation. So this is what we have at this point. This is only notice. We're not filing any action with the state.
Okay, so let me just verify with the clerk of the court and make sure there's not something else that we would need to do.
Okay.
On our end.
Okay. Thank you.
Oh.
Gotta wait for the beep.
Gotcha. Thank you.
You're welcome.
Guys must be speeding and be way too comfortable here.
Hmm. Should I ask him his name before he left? There he is.
Alright, so I actually just spoke with, our general counsel,
Hmm?
so what I'm gonna have her do is just come down and just check to make sure and see what
Okay.
needs to be
Yeah,
done.
yeah. The other states are doing it just through correspondence or
Okay.
or ex parte, but this we're not starting a case because we're already at the federal level because it's a habeas. Any one of the petitioners within the procedural situation will meet at one level, and since we're already at the Supreme Court level, Mr. Del Schmidt would be meeting at that level. So there will not be any case opened up with the state of Rhode Island. We're just hoping to mitigate these issues before we get there because it's a lot easier to do it through self-reflection of the judges rather than through action of the court. Okay,
Yes,
thank
he
you,
should
sir.
be down in a few minutes.
Awesome, thank you so much.
No problem at
Thank
all.
you. And what was your name, sir?
My name is Justin.
Justin, thank you. Are you a deputy clerk, sir?
I am.
Okay, thank you.
No
Thank you.
problem.
Thank you. All right, bye.
Hi.
Hey, how are you?
Good. Hi. My name is Christina
Hey,
Shapesky. I'm
Tanawah
Deputy General
Downing.
Counsel.
Okay, nice to meet
I'm
you.
sorry. What's your name again?
Tanawah, Downing.
Tanaway.
Yes, ma'am.
That's
Yes.
an interesting name.
It's native. It means glorious eagle and Sioux. Yes.
Oh, what does it mean?
Glorious eagle and Sioux.
Oh, beautiful.
Yeah, thank you.
So there's a lot of words here. How can I help you? What's going on?
Okay, so this is simply a notice. All we're doing is just providing notice. This is the 30th state. We have 32 that we need to provide this notice to. But when a state enacts its own alternative legislation and then substitutes it for the provisions and guarantees of the Constitution, that's a problem, obviously. So when the state of Rhode Island permits their prosecuting attorneys to charge by way of information as opposed to indictment in accordance with Clause 1 Amendment 5, then we have an issue. This case at the United States Supreme Court, and we're trying to get the last provision of the Bill of Rights Incorporated, the grand jury clause. The grand jury is obviously required. Clause 1 Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. The prosecutor's obligation is to ensure that there's a grand jury indictment there before proceeding. And so then when the prosecutor relies upon the inferior state statute to deprive a person of right guaranteed by the Constitution, we have a crime that's been committed. All that this is directing the judges and providing notice. We want the justices to be aware of this situation so that hopefully they will direct the judicial officers within the state of Rhode Island to act in a constitutional lawful manner, and we can mitigate any further litigation with the state of Rhode Island.
Okay, so you are obviously very well versed in everything that you
Yes,
just
ma'am.
said.
Thank you.
So I need you to dumb it down a little bit for me,
Okay.
because the issue that we have on our end is that, if you're trying to service with notice or a lawsuit of something, I don't have the
Yeah.
authority to accept that.
But-
That's done by the AG's
And this
office.
is not a lawsuit.
Okay.
Well, so there's a problem there. So all we're doing is we're providing notice to the agent so we can provide notice to principal. Because when the judges rely
Am I
upon...
the agent in this case?
No, because you're actually part of the executive side.
Okay, so
You're on the enforcement
okay.
side. So you would fall into the executive branch, which means that we wouldn't be providing notice to the judicial officers by providing you as the agent. So if we brought the notice to you, then it wouldn't be under the judicial. We have to go to the agent of the judicial branch, which just so happens to be the clerk of court. So this is the
Okay.
mechanism to reach them. Now we've already served.
look at this?
Yeah, absolutely.
Okay.
We've already served the attorney general.
So they have already received notice?
Right. Yeah,
Okay.
We did. We did that back in April. And so now we're circling around with the judges, which we need the judicial officers now to be made aware of the situation.
And who else are you serving with this documentation?
Just the attorney general, and so the top executive officer and the top judicial officer.
Okay.
And that way we can, I mean, again, all we're hoping to do is that they'll read this and they'll say, oh, yeah, they're right. We do need to do this because this is an obligation that we have in this constitutional codified, and thus direct their agents to do it lawfully.
So hypothetically speaking, what if we say you're wrong? Then I'm assuming there's some type of litigation
Then
that
we would
follow
have to
from
bring
that.
you. We would have to engage enjoin the state of Rhode Island into the litigation we have against the state of Washington.
Okay.
So what you guys do is you don't have a facial constitutional violation regarding the Fifth Amendment here. What you guys do is you guys. Sorry.
Are you recording all of this?
I am, but only on me, and
Okay.
and it's only for my protection, because this has been a very dangerous situation, if you can imagine, because this affects roughly 700,000 people across the United States of America that are currently imprisoned. They did not receive an indictment by grand jury, despite the fact that it's required by Clause 1 Amendment 5. So this is a big deal.
Okay.
And the fact that the country's not talking about it is a little bit difficult, because we're already at the Supreme Court, and yet we could be waking up in a matter of weeks with finding out that 700,000 people have to be released from prison because they did not receive the
Do you have litigation? I heard you mention the state of Washington. You already have litigation pending in
So
Washington?
we started the case back 9 years ago against the state of Washington.
Do you know the case name of that?
Downing versus Washington. Yeah. So
Any-
so
State or federal court?
it started in the state, and then we moved to federal. Then we moved through all three levels of the federal circuit. Yeah. And so a facial constitutional violation would be one where the law that was created functions directly contrary, that it can never function lawfully. And so that's the case with the state of Washington. The state of Washington's inferior provision of their constitution says no grand jury shall be drawn assembled in any county. So the way that law is created, it says we won't do a grand jury at all, which means that that's a facial constitutional violation. There's 13 states that are that same way, including the state of Connecticut and the state of Pennsylvania. They say we will not conduct a grand jury at all. Those are facial constitutional violations. But where Rhode Island has an issue is that you guys permit your prosecuting attorney to charge by information or indictment by their discretion. And discretion, you can't apply discretion with regard to one's obligations, because a constitutional obligation must be performed, because if you could, then that would mean that the prosecutor is able to pick and choose who has a constitutional right and who does not, which means it's an equal protection issue under the 14th Amendment.
So just to dumb it down for me, because clearly you are
Yeah.
very well versed in
I'm
this. and
preparing to go to the
Yeah,
Supreme
no,
Court,
and I
yeah.
just showed
Okay.
up 2 minutes ago.
No problem.
The crux of the issue is with respect to grand jury and how prosecutors can and cannot proceed, because there's some type of, and again, I'm not 100% familiar with this process of grand jury, but they either can or cannot choose to use a grand jury. So you have provided notice to the AG's office about your concerns with respect to this, and now you're also providing notice to the Supreme Court with your concerns with respect to this, because it is your view, and I haven't researched anything, that this is an improper procedure.
What-
And you have litigation pending in Washington and other states?
Yeah, so
Okay.
so we've already got some other states that are enjoined because those 13 that have a direct facial constitutional violation. You know, we can't ask them to correct the improper behavior of the agents. They're just outright not doing it. So on the facial constitutional, they're already enjoined. We've got those states involved, and we're going to get that addressed, and it will prevail because obviously the Bill of Rights was adopted, codified on December 15th, 1791, and it's the law. We got to
Okay.
follow it. And so when the Constitution, Clause 1 of Amendment 5 says you cannot hold someone over for a capital or infamous crime without an indictment by a grand jury, that's requirement. That's the obligation. And so as a result, when you fail to have because remember the Fifth Amendment they're all deprivation provisions. So it doesn't say you have the right to grand jury. What it says is that you can hold someone over, but in order to do that, in order to create the deprivation, you have a prohibitory element that's attached to it. And the prohibitory element is the fact that you must have an indictment by a grand jury. So when they don't have an indictment by a grand jury, then that means that the detainment or the deprivation was unconstitutional and gives rise to injunctive relief.
Okay.
So each one of these people that are being charged improperly with the improper charging instrument by the discretion of the prosecuting attorneys, that is not a constitutional outcome, because if the arrest is unconstitutional because you did not have lawful authority to do it because you breached the constitutional obligation, then that means that what's produced from it must also be unconstitutional, because the maximum law is any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So I went to breakfast this morning with a congressman here in Rhode Island. We had a long discussion about this. I want everybody to know I'm not trying to break anything. I'm not trying to get anybody into trouble. I just want us to know that grand jury is one of the most important things to protect the innocent from hasty malicious charges. That is the one thing that will lead to arbitrary and capricious arrests. And we see that in a lot of different states, because if you don't allow for a third party, a neutral, unbiased third party, to review the state's accusations, and not just the judge who works for the same entity as the prosecuting attorney, then innocents will suffer, because you get too focused on what you believe to be the truth, especially when someone comes and says that something happened to them, and you attach onto that story, then you suppress the other side from telling theirs. And that is the purpose of grand jury. Grand jury needs to be there, normal people to review the government's allegations.
Okay.
And so it's extremely important.
So
Extremely
obviously I
important.
can't talk to any of this because
Yes, ma'am.
this just happened.
Yes.
But just so I understand today, so that I don't get myself in trouble
Yeah,
some way or
yeah.
other, right now you're providing a notice to the courts as well as a notice to the AG's office.
Yeah.
Your hope is that the courts follow some of the edicts listed in your notice,
Yeah.
and then if not, then there could be some type of litigation down the road, and no one
Yeah.
really wants that. But that's just kind of sort of where we're at right now.
This is just self-reflection. So,
Okay.
so this right here, it's very, very simple and clear. And when you read it, when the prosecuting attorney brings the incorrect charging instrument, that is the crime of deprivation under color law. It's the very definition of it. And so that's the part A here. And then when that prosecutor brings the incorrect charging instrument to the judge has a duty and responsibility to ensure that the proper documentation is in place. When he fails to do so, because he relies upon the breach of obligation of the prosecutor, now they've established a conspiracy to obstruct justice. And so now we have a bigger issue. This is letting the justices know that there are crimes that are being committed. I don't want to pursue that route, because I think that's going to be really messy and bad. But if we can reflect on it and see, okay, yeah, this is right, then we can mitigate our culpability within the conspiracy by, one, directing the officers to do the right thing. Because when you have a conspiracy, the laws of conspiracy state that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined defendants in the action. So upon providing notice to the judicial officers here in the state of Rhode Island through their agent, then they have been made aware of the existence of a criminal conspiracy. And as a result, to mitigate their culpability, they can't be negligent in this. They must take action and address it. Now, to mitigate your culpability within the criminal conspiracy, you have to do one of two things. One, you have to notify the authorities of the crime, or two, you have to notify your co-conspirators of your intent to no longer participate, but that must be done by some affirmative action. So every single one of these officers can mitigate their culpability within this criminal conspiracy by saying, I'm not going to participate anymore. Come over to the right side, come over to the lawful side, and that's all I'm asking everybody to do. It's going to be a lot cleaner to do it this way than it is the other way.
Some type of litigation.
Yeah, because everybody can make their independent decision. When I found out I was doing this, I had to make a decision myself, and I chose the lawful side.
Are you an attorney in Rhode Island?
I'm an advocate elsewhere.
Okay.
Yeah.
Okay. All right. Just so that I understand, because obviously,
Yes, ma'am.
this has to be discussed.
My law is in substantive law, so I graduated with substantive law, so I'm law enforcement forensics as opposed to adjective law, administrative law.
All right.
Okay.
Well, thank you very much for your
God
time.
bless
I
you, sister.
appreciate
Thank
it.
you. Thank you so much.
Have a good day.
Yeah, thank you. Thank you. service been provided on the state of Rhode Island on behalf of the Del Schmutt family on both the clerk of court and it looks like a assistant attorney general. So we are going to head on out to the Capitol and have another little discussion here, but I think that went fairly well. Thank you guys so much. God bless. Good afternoon. So we're here in Providence, Rhode Island, and just moments ago we provided service on the Rhode Island State Supreme Court on behalf of the Del Schmutt family for the crimes of deprivation of rights under color of law, conspiracy to deprive of rights, kidnapping, and other crimes as ascertainable by the evidence on the record. We also had the state's counsel come down. One of the assistant attorney generals had a great conversation with her, and I think it went well. You know, we're in the situation that we're in today just from ignorance, right? We've gotten to the point that we're at just by our own fault because we've forgotten what it is that makes America America. What makes America America is American laws. So when we don't follow American laws, then we have a breakdown of America. I don't think that anybody was doing anything wrong necessarily. I don't think that the prosecutors understood, that they were causing such injustice, and I don't think that any judges necessarily knew that they were implicated in this act. We've gotten this point out of just straight ignorance. So, it takes some time to get people to understand that what you've been doing is wrong, what you've been taught is wrong, and this is the right way to do it. And so, I accept the fact that I've had a lot of obstacles, a lot of obstruction in this because they don't want to recognize the fact that they could possibly be doing something wrong. But I think we're coming to the point where they are starting to understand that. They're starting to see that, yeah, there is a different way that's supposed to be done. Just because you've done it one way for 100 years doesn't make it right. Wrong will always be wrong. Right will always be right. So if you're doing things wrong because you were taught wrong and you just continue to do them wrong, well, it's still wrong. It doesn't matter how many times it's been done or how long it's been going on. Wrong is wrong. And today we're doing it wrong. The purpose of the grand jury is to protect the innocent from hasty or malicious charges. When you eliminate that particular part of the process, then you have arbitrary and capricious arrests that occur and you have mass injustice. And that's where we're at. Anybody in America can be arrested for any reason whatsoever, brought into a sham process and threatened, intimidated into saying that they're guilty by this system, right? And it doesn't matter whether it was with malicious intent or not. If it's wrong, it's wrong. There's a lot of people that are currently sitting in prison today that are innocent, that shouldn't be there. That the system has said that it's wrong because they've only accepted one side of a story. Truth will always lie somewhere between two stories. And if you don't listen to the other side, you don't consider the other half of the story, you will never know that you found truth. Justice will never be administered, and truth will never be ascertained. So it takes time to bring about this understanding, right? And a lot of people have asked me, like, what makes me think that I could do this? Why has no one else figured this out? And I don't know. I don't have an answer for that. But what I can say is that this has happened. I don't know why. No one has figured out these elements, but God's blessed me with some vision, some understanding that no one else had. But we got to remember that it all starts with one. You see, we live in an incident-driven society. That means that there requires an incident in order to drive change. America doesn't just wake up one day and say, "Oh, yeah, we're doing it wrong. Let's go ahead and start doing it right." No, you have to have someone bring a reason to do it, and that's why. Power isn't the guns, it isn't the badges, it isn't the title. Power is the ability to influence others in their future decisions. Power comes from your words, because if you can inspire others into believing what you believe in, right? If you can present your faith to others and have them believe in and have the same faith, then you have power. You can influence those people and bring them about to the future that you have envisioned. So change. Anybody can do it, because the power to change is the power of one. It only takes one person in our society to bring about a change, because it only takes one person with a vision to be able to see something different and want to actually take the time to bring it into fruition. So even if you guys don't believe it, this will happen. It's the right thing to do, and it only takes one. And as I continue to get more and more people to see that there's something different, that there's a better way or correct way, and that we're doing it wrong, we get one step closer to to that change and the system that we were promised 243 years ago. So, again, when a state enacts its own laws that are contrary to the Constitution of the United States, that breaks down America. When the state of Rhode Island says, well, we're not going to do what the laws of America says we have to do, then you're not part of America anymore. And we don't want to head down that path any longer, because we don't want to have a breakup of the nation so that Rhode Island is its own country and Washington's own country and Texas is, because it's not in the best interest of the American people. It's not in the best interest of all of us. You know, e pluribus unum. That is our country's motto. Out of many comes one. And I think that we're at the point of actually bringing about that motto, because we never actually became a union. We've always been a confederacy because the states have never recognized the fact that they are not sovereign. They gave up their sovereignty to join the union. You give that up to join and be a part of the greater whole. That means that you don't have local interests and views. You know, George Washington in his farewell address, he stated one of his greatest concerns for the dissolution of our country. What he said is, foreseeing the causes which may disturb our union, I find as a matter of serious concern for the characterizing parties by geographical discriminations whence designing men may endeavor to excite a belief that there's a real difference of local interests and views. When a state says that we can act differently from the rest of the nation, you have a local issue where they believe that their interests are more important than the nation's interests. And that's not how it works here. So in America, we come together as a representative nation, recognizing the fact that California's got different cultural differences and views than the state of Rhode Island. But they're both equally as important in the grand scheme of things. That's why we have an equal representation within the central government. Every single state has 2 senators, equal say, right? Now the population differs within the Congress, but every single state has equal representation, equal say, because it doesn't matter how big you are. We recognize the fact that we have a culturally diverse nation with lots of different groups of people, and so we need to value the input and the points of view of each one of these autonomous geographical locations. The state of Louisiana is not going to have the same cultural values as the state of Alaska, right? The state of California is not going to have the same cultural values as the state of North Carolina. That's why we have to have these representatives come and speak out about the needs of their people, about what they value. And so when we have local interests and views that are imposing their will upon the rest of the nation, it causes a breakdown of the union. Each one of these states are now sitting here saying, well, you know what? I'm not being heard in the central government, so I'm no longer going to participate in the central government, and that creates a breakdown of our union, and it leads us to dissolution. And that's exactly what Mr. Washington was talking about in his farewell address when he said that the greatest concern for our country is the characterizing of parties by geographical discriminations, whence designing men may endeavor to excite a belief that there's a real difference of local interests and views. So I hope that the last 40 days, because we're going into our last two states right now, we're almost done. I hope these last 40 days that I've inspired some of you to believe in America once again, because I believe in us. I believe in it, and I believe with all my heart that we're going to make the right decision, because we have always and will always choose to do right when shown that what we're doing is wrong. America's made a lot of mistakes, but I'm proud to know that we have resolved to learn from each of them in order to be better and stronger as a result of them. So we now stand at the precipice of yet another major crossroads for our country. Will we follow the path of our ancestors, or will we follow a new path of our own? The question is up to the people of the United States. Do we want to continue down this path of enslavement, or do we want to make all men free? And that's what I've been out here doing. I want to inspire others to the same vision that I got. And we can all believe in that, because it's simply the principles and values of the American people. So thank you so much for being with me. Thank you so much for supporting me and following me. And it's been an honor to be able to do this. Love you all. Thank you. God bless.
About to go down, going all out. This is right now, yeah. Together we rise. It's about time. Unleash the power. why you never fade, still breaking the mold, no matter what it takes.